Mark, I think we got everybody.
Okay. Okay. Well, thanks everybody for joining us today. Unfortunately, Atticus Zhao is not feeling well. He's lost his voice. He nowadays everybody in China always say they have the flu, but they don't have COVID for some reason. I mean, but hopefully he'll get better. But so Jerry, you haven't got COVID, have you? Jerry just coughed. But anyway, so Jerry will soldier on by himself, and we'll talk today about these new rules, which I think help facilitate cross-border data transfer. I think it's mostly loosening or making it easier and more workable. So, hi, Jerry. So we'll just kick it off, I guess.
Yeah, sure. So welcome everyone. So today's webinar, as Mark mentioned, so we wish to take this webinar to address the recent hot topic in China. It's about data cross-border transmission. So as you may have heard that China just released the final set of rules governing the data cross-border transmission. So what we do here today is we enter into the new rules and to extract the main key points to you and let you know how you can your China business can take advantage of the new rules.
Okay, great. Okay, so maybe Jerry, before we kick off, so these new rules, there's a bunch of them, and what in a big broad brush effect, what's the main thrust of this? Like, what's it? Why are these new rules important?
Yeah, Mark. So I think before we enter into the new rules, I think it should be like helpful, also interesting to look back a little bit to see the background of the new regulations. So essentially, since our team has been followed the data compliance in China for many years, so China actually has spent like a long time on formulating its own like sets of data cross-border transmission rules in China for the China. So back to the time in 2016, so that was the year that the first like cyber and data related legislation in China was released. It's called PRC Cybersecurity Law. So it's 2016 is almost like 10 years ago. So CAC is called the Central Space Administration of China, the major authority in charge of the cyber and data security in China. So the CAC has already like organized a number of like internal webinars, seminars or roundtable discussions. They invited a lot of like law firms, professional agencies, or even some like government authorities, they are like research institutions to participate in the discussion on what's the general framework on the governing the data cross-border transmission. So also for us, we participate in these kind of like discussions and we raise our ideas, a lot of like ideas coming out. So by generating all these ideas, starting from 2017 and also like 2019, China released several versions of like draft national standards or even administrative regulations to trying to set up the general framework on the cross-border transfer. But however, all these ideas were somehow like replaced by the final answer released in 2021, along with the promulgation of the data security law and the PIPR personal information protection law. So according to the final answer clarification, so now we have 3 routes for companies in China who wish to transport data from China to other countries. So the first rule is about security assessment. So this is carried out by the central like CAC, and this is the most strict path for companies for the data export. So security assessment is mainly for companies who are transferring a massive amount of personal information, or even no personal information is involved, but they are transferring some non-personal information with certain level of sensitivity data. So others like apart from the security assessment, we also have the SCC filing. So SCC filing standard contract clauses as you will see, it's a concept that we copy from the GDPR. But in China, it's slightly different. So in China, it's not like close standard template clauses. It's a standalone independent contract called standard contract. And this contract needs to be filed to the CAC, the Chinese authority, before like transmitting the data. So this is for and the SEC filing is generally for is only for the export of personal information. A third one is the certification. Certification is like also a concept copied from the GDPR, but in practice, it's the authority has not released too many details on how to like use the path of certification. So this is somehow at current stage out of discussion. So currently we are now relying on the security assessment, rely on the SEC filing.
So Jerry, just to make it simple for people, so the security filing is the gold standard. So if you're doing something with infrastructure companies or massive amounts of information, then you need to have a standalone security check with the Chinese Cybersecurity Administration. They actually check your system and approve you. And then for the other ones, if a certain threshold's met, you have to use their standard contract. Is that right?
Yeah, you are correct. So and also Mark, so the reasons for the authority releasing the new regulation this time is because in terms of the implementation, so the security assessment was officially launched about 1.5 years ago. It's about like 2022 September. So at that moment, so lots of like automobile companies or also like the internet giants, leading companies, they are all busy on preparing for the security assessment. So both security assessment and SEC filing mainly request two documents. One is the cross-border data transfer agreement. So this is somehow quite straightforward because anyhow we have the like government template issued by CAC about standard contract on transferring the personal information. And in terms of like security assessment, which may potentially involve the transfer of non-personal information, so we just need to like polish and revise the standard contract to make it applicable to a wide scope of data. And for SEC filings, standard contract will be directly used for the filings, and non-context is allowed to be changed. So for the agreement part, it's easy, but in practice, the difficult part is always about the self-assessment on the transfer. So it's called PI assessment or self-assessment, but it's generally the same document that requires the companies who export data from China to prepare or to set out all the details about the transfer in that document. So for security assessment, we are talking about a 200 or 300 page Chinese language long report. And in practice, CAC, once this report is submitted to CAC, they will like review the report line by line, words by words. And in practice, it's not rare that the authorities will ask like up to 10 rounds, even 20 rounds of like comments, rectifications, updates of the report. So you will see this is extremely burdensome. So companies who is triggering the security assessment will normally spend at least 6 months to prepare, and maybe another 1 year to successfully undergo the security assessment. And
how long after you get the security assessment? How long does it last? Do you get it forever, or do you have to redo?
According to the old rules, it's 2 years, and according to the new rules, it's 3 years. So companies are really what we see. Some of our clients are doing that. We're doing that, so it's rather struggle because they need to devote a team, saying at least 10 people inside the company and together with the support of the lawyers team. As you know, we work together, drafted the report, send it to CAC, explain the details to the CAC. This is all quite like a nightmare for these companies. Yeah. So SEC filings was officially launched 6 months after the security assessment was launched. So it's about 2023 March. So still, for the data cross-border transfer agreement, it's easy, but we also have the so-called PIA assessment report. But compared to the security assessment, in practice, normally this is much more simplified from the version under the security assessment. So the report, but the report is still like um, almost like 100 pages long Chinese language, because according to the outline required by the CAC, still a number of like details need to be reflected in that report. But practically, companies will need to like spend 4 months or 5 months to do the data mapping, to know everything, to get knowing everything, and also prepare the report. And the report will be submitted for filing, and even it's a filing, so theoretically the authority may still reject your filing within like 15 work days if they consider the report is not good enough. So
And do they have lots of comments while you're trying to file it? Like you said, the other one was like 10 or 20 rounds of questions.
yeah.
But on the filing, is there 1 round or 2 rounds, or how long does it normally take with the authorities?
Yeah, it's normally, I think it's still like several rounds, but not as prudent as the security assessment. The comments we received from the CAC in terms of the PI report under the SEC filing is normally about like formalities. It's a lot more about like substantial like comments to the contents we disclosed under the report. So particularly it is simplified, much more simplified, but still very time-consuming and onerous. And essentially, and in particular, the SEC filing attacks everyone, every companies. That means some of our clients, they are like B2B multinational companies in China, and it's very normal for these companies to transfer employees' personal information through the Workday or similar like systems. And normally, some of these clients only has like 20 or 30 employees, and they were asking, "Oh, are we still need to like do the SEC filing?" Our answer was yes, because the law, the old regulations, did not provide any exemptions. So even theoretically, even you are transferring one piece of personal information, the SEC filings will still be caught to these companies. So these are all the like complaints, all the like burdensome, onerous burdens imposed to the companies who is doing business in China and who involves the data cross-border transmission. And based on this background, so the CAC released a draft of the new regulations, which provides some certain exemptions in last year, 2023 September, end of September. But so that's why. So at that moment, we have like about 20 clients at hand. So who wish to doing the SEC filing, but we asked them to pause a little bit to see what will happen next. And because we heard from the authorities that the general trend is that they wish to loosen the very high demand like cross-border data rules, and they want to provide some exemptions. And now, after 6 months waiting, so we have the new rules at hand. It's just released last month, 3 weeks ago, and it's indeed provides lots of like exemptions, which provides benefits to MSE, to multinational companies. So the new regulation, this for this round, including A is the data flow regulations. This covers, provides a general rules on how to the new rules on what the exemptions are and how companies can apply for these exemptions. And B and C are the two guidelines. This is more like a practical documents. It's like a guiding companies who wish to do the security assessment or the SEC filing. They tell you about what documents is needed and what the procedures will be. It's kind of like optimized from the first version, so first edition. So this is the background. I hope it's
So it all
helpful.
became easier. So everything has become easier. These new regulations don't make anything tougher. They just make it easier. they give you exemptions and they lower the requirements for certain things.
Yes, yes, and I think it fixed the old practical problems and it answered most of the complaints, especially amongst our clients. Like I mentioned, the B2B companies are now largely able to apply for the exemptions for HR scenarios, which we'll discuss later.
Yeah. Okay.
Okay. So after the introduction of the backgrounds, I hope it's helpful. Yeah. So let's look into the new rules. So first of all, after the after revising the threshold on triggering the different rules for data export. So now the highest level security assessment only has they set a new rules. So um, essentially, if a company is transmitting personal information of more than 1 million individuals, this will need to be undergo the security assessment. And if a company is transferring sensitive personal information, which is for example, sensitive personal information contains like personal IDs, biometric data. So if for transferring sensitive personal information of more than 10,000 individuals, security assessment will be triggered. And item B is about CIOs. This is a critical information infrastructure operator. This is like a codified concept in the PRC law, refers to these big companies who operate the important systems, which covers a massive amount of personal information or other non-personal information which may be related or threaten the national security, public interest in China. But for CIOs, this is in our views, and not very much like foreign investments in China are identified as CIOs. But practical wise, it's like if a company received a notification from the authority telling you that you are identified as a CIOs, so you will be the CIO. Otherwise, there's no need for a company to consider themselves as a CIO.
I think the first one, so personal information of more than 1 million people. So I guess nobody has 1 million employees. No MNC has 1 million employees in China. So this would be mostly consumer type of information, I would assume. And then the sensitive personal information, the 10,000 could affect more people. That could affect like a cosmetics company that has an app that takes photos of people's faces and feeds back. So I guess that's the kind of companies. And then the CIO infrastructure, that's like typically very large state-owned companies, the banks, financial institutions, or the networks, etc. So again, for MNCs, pretty unlikely, I guess.
Yes, indeed. Yes, and the item C is about important data. We'll also explain what's important data, but it's like a non-personal information, but it's related to the national security or public interest in China. So authorities in every industries, they will be responsible to formulate a very detailed list on what kind of data will constitute important data. And according to the new rules of this time, it is now clarified if any data set is not set out in the important data list, so companies will not need to concern whether any of data might constitute important data.
So that's like the automotive industry's already got their guidelines out, I think. There will be like pharmaceuticals, life sciences. So this stuff could be things like genetic information, pricing of big commodities, I guess, these kind of things, isn't it?
Yes. But as of today, so most of the industrials, they do not have their very detailed list on the important data. Automotive industry is one of the industries that already set out the general types of important data, but it's not too specific to constitute a list. So you can understand that till now, there's no very specific list in any industry in China that clearly set out the important data categories. So so this is a future change in the next maybe in later of this year or someone close.
So people have to be still concerned because I think important data, we're sometimes surprised. We had a client once that was doing a monitoring of crops, and we didn't realize that could be a state secret if you would like report in real time outbreaks of an insect infestation, because that could affect pricing of major crops where China's state-owned enterprises buy a lot or sell a lot. I think also information about the use of iron or investment public works can be important data. It's a bit like state secrets, things that you may think are harmless, if they have a real impact on the economy or national security, it could be important data. So I guess until things are very clear, if you feel that you're doing something sensitive, you better check if it could be considered important data or even a state secret, I would guess.
Yeah.
Okay.
Yes, Mark. So this is about security assessment. So what I heard from the authority said, I mentioned, so the security assessment procedure-wise, it is very burdensome. But I heard from the authorities that in the future, the security assessment will still be very prudent because this is the highest level, most stringent path for companies to transfer the data. And the scenarios which triggers the security assessment will normally refers to the situations that massive amounts of personal information is involved, or like important data or quite sensitive data is involved. So that's why the authority will keep the security assessment procedure as still very long, very onerous, and they will keep their very prudent review on the report submitted. So for companies who is potentially triggering the security assessment, let's take another thought and to see if there is any possibility to avoid the application of the security assessment.
Yeah, but you might want it because if you're in let's say, I guess if you're in autonomous cars and you're dealing with real-time, information from the car to somewhere in Europe to say if it's functioning properly or stuff like that, because that would be very sensitive data because you would know who is where on the road, how many people are in one place all at the same time. So for that kind of company, it might be even firstly, a good protection against something going wrong. If something goes wrong, you'll get in big trouble. But secondly, I guess it's a barrier to entry for other people to get into that market. So I think the security, and I know that they're relatively new, and you say now they've extended it to 3 years. I guess the thing is, once you have the basis agreed, the renewal will be on the basis of the old report and just be updated. So I guess if you're really in that kind of area, it's probably worth doing because if something goes wrong, it would be a good protection against claims and everything else.
Yes, Mark. So you are mentioning the situations that, like for automotive industries, there are like a volume of the processed personal information is far more than the threshold. So for these kind of situations, it is not arguable. So people simply do not fight and just directly prepare for the security assessment. But indeed, in practice, we heard some of the cases. For example, some like ADAS projects that they may involve the personal information, but it's close to the threshold. So it might be triggered assessment, or it might be not if we arranged the volume, annual volume in a very strategical way. So I think this will be.
What is that? What is the ADAS?
ADAS is like for self-driving cars. It's about automatic driving assistance system.
Okay. Well, see, I think that's somewhere which I was actually thinking of. You might not want to avoid the threshold because, what would happen if something goes wrong? Because that's the thing about the automotive industry. If somebody could hack into it and then take over cars like a terrorist incident and kills a lot of people, you probably would like to have that security assessment. So I think, people have to look back and think, why is there a security assessment? It's not just for the fun of having a security assessment or to create jobs in the Chinese government. I guess it is really to, target and give people confidence that their personal information is being treated correctly, but also certain things that could affect life are also protected from a cybersecurity view. So on that case, with the automotive driving, I would have thought that's a case you probably do want the protection of a security assessment to protect yourself if something goes wrong. Because if it goes wrong, then I'm sure people will interpret it that you should have had a security assessment, I would guess.
Yeah. Okay. Next page is about SEC filing and the certification. As I mentioned, the certification is generally still a concept, so it's not being implemented by the authorities. Sometimes we made a call to the authorities asking about certification pass, but still they were answering us that okay, they're still working on that, and still quite a few details need to be confirmed. So certification is out of practice at current stage. For SEC filing, it's compared to the security assessment, it is applicable to a much wider scope of the companies in China. So generally, which situation will trigger the SEC filing is that if any company is transferring personal information within the current year, the volume exceed it should be 100,000 personal information, but less than 1 million individuals. So this will trigger the SEC filing. But this is not calculating about a sensitive personal information. And for sensitive personal information, if the annual transfer volume exceeds 10,000 individuals, the SEC filing will be triggered. So SEC filings, in our experience, it's a lot more straightforward. Even so, I mentioned that this is still needs several months to be prepared. But essentially, to our experience, the most efforts will be the data mapping in the first stage. So to collect and to clarify all the facts around the cross-border transfer. Afterwards, it will be a very procedural and standard preparation of the documents, and the law firms will help you to find a way to best reflect these facts under the a PI assessment report to reach the conclusions that and to convince the authority saying that the transfer is okay to go. So this is the SEC filing.
So what happens though if you're like a consumer brand that is doing okay in China, and last year part of your loyalty program, you have personal information of say 60,000 people, then you don't need to do the SEC filing. But this year your business is really booming, and you've already by March or April you've already got 100,000 people, but you haven't actually applied for the SEC filing. What do people do? Do they continue their business and just do the filing in parallel, or do they really actually stop sending the PI personal information until they've got the filing?
I think in practice, there will be a period, a timing that a company realize, okay, this year we are closing to that threshold and we need to get prepared. I think this will be very practicable. For example, maybe in April of the year, so the volume already exceeds 90% of the threshold. So the company may start to prepare for the SEC filing in advance so that they can be submitting the filing application on time.
Yeah, but what happens if they can't? Because things go viral. Somehow people like that lavender bear thing suddenly becomes very important. So what do people do? I guess the thing is they just would try and put the filing in as soon as possible. But I guess you'd have to tell people that you've got more than you expected. But
Yeah,
I assume people don't stop their business waiting for the filing. I mean, it'd be nice to do the filing beforehand, but
yeah, Mark,
sometimes people...
Yeah, Mark, I think you are right, because according to all of our communications with the authorities for a long time, they always give us the information saying that okay, the companies it's not mandatorily necessary for the company to cease their business, and as long as they can like submit the filing or submit the application as soon as possible. Normally, these reports and applications could be retrospective to a certain extent. So, for example, if the April we exceed threshold, we get preparation, and we finally get everything prepared in around like September. So it's still like tolerable to the authorities to do that, as long as you are like you can prove that companies are like actively prepared for these filings matters. So this will mitigate the risk a lot.
Okay.
Yeah. Okay. So moving to the next page is about the key points, because the new rules of this time they started to provide the exemptions. So the first exemptions is about if no PI, personal information or important data is involved in the cross-border transfer, then the so-called three rules, the security assessment, the SEC filing, and the certification could be not triggered. So this is a more of like emphasize, because for all the times the Chinese rules on cross-border transfer only applies to personal information and important data. So if you have no important data or personal information to be transferred outside China, so absolutely the rules will not be applicable. But this, I think, this clarification helps to set the point that the rules are only applying to the PI and the important data. So this is the first exemption.
So example of that would be saying like, if I've got a manufacturing company in China and I just want to send details about the price of materials or
Yeah, indeed.
defects in the
Yeah,
production
indeed.
or that stuff. So all that stuff is not a big issue.
Yeah. Indeed, also like the products, like information, some business descriptions. So these are all fine.
Okay.
Yeah. So exemption two is about also we know it's the exemption two is about if the data transfer does not contain any domestic personal information or important data. And this is like a company in China receiving data from abroad, from overseas, and they process it in China and then directly transfer out. So in this situation, the three rules will not be triggered. So this is the idea has already been like reflected in back in 2017, I think, in the draft national standards, that the transiting data will not be caught by the countries like data cross-border transmission rules. And also, it's to my understanding, this is also existing concept rules in GDPR or in Singapore. So now we just like to clarify these rules, and this is to helping the companies if they wish to set up their data center in China. So and they are doing the transiting data processing, and they will not be caught and they will not be bothered for the China internal government procedures for data exports.
Yeah, but I guess their home jurisdiction might not be happy if they ship all their personal information data to China. So I guess that would be an issue they'd have to check.
Indeed, yes. So moving to the next page is about exemption number three. This is about like uh, if transfer of personal information is carried out for the performance of the contract with individuals. So this will be the government procedures in China will not be necessary. So this according to the new rules. So please note that this exemption only applies to a situation that the individual is a party, contractual party of the contracts. So if it's about like a general or subcontracting things where the individuals is not a party of the contract, so please be prudent to use this exemption. And also the new regulations made some examples of the scenarios of which kind of like contract or business will be explained as a strict necessary. So it's like cross-border shipping, delivery, banking things like remittance, payment, account opening, and also for travel bookings, for visa applications, for exam services such as like IELTS test, TOEFL test. So all these 8 scenarios is expressly listed by the new rules as the typical situations. And we've made call to the authority, and we asked if we have any more scenarios in addition to these 8 scenarios. Can we apply for these exemptions? So currently we got answers that no. So currently the authority inclines to only limit the exemptions under the 8 scenarios which are expressly set out in the document.
So, but these exemptions are all very personal exemptions. So these are individuals doing something with overseas. So I guess it's limited that way. It's really like just to help consumers do things overseas, like book a hotel or book a plane ticket in America without having somebody have to deal with all this stuff. So I guess it makes sense. I'm assuming if there was a consumer issue that doesn't fall in those 8, although I think it's pretty broad, like a remittance, a delivery, it's hard to imagine what else would be involved. I don't know about, what about universities? Is that under examination services? So if a Chinese student wants to apply to London School of Economics, do they have to do anything, or does it fall within these exemptions?
No, I think it's literally speaking, it's not like covered by the examination services. So because like academic things or having a course outside China, so this is not only about examination. So universities are now not very recommended to use these exemptions.
So what are universities like, overseas universities? They have thousands of Chinese students. Are they doing anything, or do they just ignore it because they're not in China?
Yeah, basically they are not in China. Since like most of the students submit their like applications from China, but their universities are sitting abroad, like in UK and US. But to be notes that the extraterritorial effect is now clarified under the general like data cross-border transmission rules. So that's saying if a company or like entity sitting outside China and it's triggering the extraterritorial effects, which means these entities, even they are not resident in China, but they are like collecting or analyzing personal information of Chinese individuals or individuals resident in China. So in this case, they will still be subject to the administration of the cross-border rules.
Yeah. So have you seen any of the universities? It's a big business in London or in the UK.
Yeah.
So have you seen any of the universities actually do anything about this, or they just ignore it or don't know about it?
Yeah, I think two universities ask us about this. They become aware of this because, just as I said, the new regulations of this time expressly mention the extraterritorial effects. Before, it's kind of like a gray area, but it's now a new issue for the universities or some other entities outside China if they are collecting personal information directly from China.
Okay. Okay.
Yeah.
Great.
Okay. The last hint is about the necessary really matters because when even the exemptions can be used, but about the scope of personal information, companies may still be very cautious because, for example, for cross-border delivery, so it will be strict necessary to have the individual's name, address for the purpose of delivery. But if you are looking for like they are like a shopping preference or even like uh, let's just make an example like a marriage status. So this is not necessary for delivery business, and this cannot be included in the exemption.
Okay.
Okay, exemption 4, which I think this is the most useful exemption. This is for HR scenarios, especially for these companies who who are just like transferring their employees' personal information from China to the global systems. So now we finally have this exemption saying that first of all, provided that the company has the internal labor rules or the collective labor contracts which can support to justify the necessity of transferring personal information, employees' personal information outside China. So, and then if the company can ensure that other compliance requirements like the consent, like assessment can be is also like in place. So in this scenario, the companies will be free of like transferring employees' personal information without undergo any like SEC filing or security assessment. So this is
Yeah.
very
So this
useful.
will be mostly included in like the employee handbook because most multinational companies in China don't have collective contracts. So this will be, it's enough to put it in the employee handbook. Is that right?
Yeah. So speaking of like a collective contract, labor contract, this is a very local concept in the PRC labor law, and most of like 99% of like foreign invested companies do not have such things. But others like the labor rules, like Mark said, this is normally it's about like employee handbook, and according to the PRC labor law, so these kind of documents need to be like discussed and consulted with all the employees of the companies or like the employee congress. And after these documents is like finalized, this need to be published and notified to all the employees. In China, we call it like we have a word for this. It's called like democratic procedures. Yeah. So the very typical example of this like internal labor rules, what we see is the employee handbook. And how to put it in practice, like is let's take it this way. So employee handbook needs to have some contents. So first of all, like to provide to reflect that the company is adopting a global level HR management. So that means all the like maybe like workday systems, they are operating globally. So reflecting the necessity of transferring employees' personal information abroad. And second of all, for each purpose, when you're transferring the employees' information, let's like have some contents in the different like sections saying, for example, so companies are providing employees with the insurance products. And for the purpose of like purchasing insurance for employees and to choose the better insurance companies, we might need to like transfer data to overseas insurance providers. And all these contents under the employees handbook, together with the like notification and the consent letter, in addition to the employee handbook. So this will constitute a very sufficient basis as a notification, as the consent, and then you can like companies can transfer the data.
But do you really need consent? Because I mean, like I think normally the employee handbooks you just give it to people and then you can update it because you know you can't negotiate with 150 employees and get everybody to agree to everything. Otherwise, nothing can be managed. So you don't really need consent. You just need to inform everybody this is the policy, I guess. Is that right?
Yeah, I think you still need a consent because employee handbook cannot be that specific in terms of like data transfer arrangements. So according to the PIPL, the companies who transfer the data needs to notify the individuals about the name of the overseas recipient and like types of personal information involved in the cross-border transmission and how to contact the overseas recipient and what's the purpose for each overseas recipient, what's the purpose of the transferring personal information to them, and how can the individuals exercise their statutory rights as a personal data subjects under the PRC law. So these are very specific notification matters, and this cannot be reflected in the employee handbook.
Okay, so if you do this with a consent letter, then I guess what happens is if there's 100 employees and 99 sign the consent, one doesn't, then that one person, his information has to be treated differently, I guess.
Yes, indeed. Theoretically, yes. And in practice, we can, there are several steps to say if some very little, like very few employees, they are insist on not signing on the consent letter. So first of all, it's the companies or like with the assistance with the lawyers, so that we can explain what what this is and what's the consequence if you sign it. And if he insists of not like sign it, we'll see this will like affect his like beneficial treatments under the company. For example, the company will be no longer able to like purchase any like overseas insurance products to that employees. Or the company has to choose the domestic ones, maybe which may be more expensive, which may provide less like protections. So just to let him know the consequences.
Just okay, good. Just so I guess that's important because normally the employee handbooks you can update it like you want as long as it's legal, but here we do need absolute consent from every person to opt into it.
Yeah, yes. So this is HR scenario. So exception 5, we can quickly skip it. It's about emergency situations. It's not very common in practice. So exemption 6 is about quantitative threshold or for companies who wish to seek for like exceptions. So firstly, it's not applicable to CIOs. So as Mark and I mentioned, so CIOs are not very common amongst the foreign investment companies in China. And also, if you are transferring personal information less than uh, um, uh, 100,000 individuals within a year, and provided that all of this data does not contain any sensitive personal information, so companies can simply like transfer the data with like consent with the agreement, but there's no need to undergo the government procedures like SEC filing.
And why does this not apply? So employees, it's because you have more data. That's why you need to have the employee exemption, because not many MNCs would have more than 100,000 people. So
Yeah, I think this happens in the situation. For example, some companies, even they are B2B companies, and they have a limited amount of like employees, but they also have like the contact information of the persons from like their corporate clients, vendors, suppliers, even manufacturers. We call it B2B contacts. And some companies, quite a few companies use the CRM system, also hosted outside China, and they might like transfer maybe say thousands of like B2B context personal information, but these personal information are very are not sensitive, like a name, like the telephone number, like the position in the company. All these are non-sensitive personal information. So I think these exemptions may also used by these like companies who are transferring the B2B context personal information.
okay.
Yeah. Okay. So at this slide, we put all together all the exemptions we mentioned because there are some general rules. So essentially, exemption 6, the quantitative exemption, is quite independent. That's saying, okay, if one calculating the volume of data to be transferred, so exemptions, the volumes under exception 1 to 5 will not be calculated into exception 6. For example, so if a company they are transferring like 200 employees' personal information. And they were also transferring like several thousand of like B2B contacts personal information. So the volume of employees' personal information will be simply removed, not be taken into consideration when assessing the applicability of the exemption 6. This is the first point. And second, you will see that under the exemption 2 to 5, like for example, the HR scenarios, employees' data will be, some of the data will be sensitive personal information because like employees, like ID card, employees' bank account, all these are quite typical sensitive personal information. But sensitive personal information will be allowed to be transferred under exemptions like 2 to 5, and but this will not affect the use of like exception 6 as long as apart from any situation that is provided under exception 2 to 5. So and provided that no sensitive personal information is included when companies are applying for exemption 6, the quantitative exemption. So both of the scenarios will not affect each other.
Okay.
Yeah. So this is the general rules. So moving forward, I noticed time is flies so quick. So moving forward, it's about sensitive personal information as we mentioned. So the reason we wish to emphasize the concept of sensitive PI is because now, as you will see, transferring sensitive personal information or not will largely determine if a company needs to trigger the government procedures. So sensitive personal information, we do have a national standard setting out all the typical examples of sensitive SPI. So like ID number, social security number, bank account, biometric data, and like a marriage status, religious beliefs. All these are quite typical sensitive personal information in China. So what companies need to do is like based on the mapping results. So let's say when applying for one seeking for the exemption in the scenario 6. So so trying to control the volume to be transferred outside every year. So trying not to uh, uh, exceed the thresholds provided by exemption, the quantitative exemption. And also, if you are transferring any sensitive personal information, even one piece, let's take a second thought on that. For example, simply we generally consider that it's not necessary to transfer the sensitive personal information of all any B2B contacts. It's not that necessary, right? So let's say if you are accidentally transferring any SPI that is not useful or necessary. So let's remove it so that we can better suit for the exemption 6, the quantitative threshold.
Okay.
Another concept we wish to emphasize about important data. But as we mentioned, so every industries will have their own like a specific list as to what kind of like data will constitute important data in that industry or area. So till now, there's no any specific list released yet. But in short future, what we heard from the authorities is they are rushing on providing such list. So this will be something happened in the near future. And let's see, and it's recommended to keep attention on the list, on such like important data list.
So I guess people will have to do a bit of thinking if something is sensitive. So I think there with the automotive, these are similar to what we discussed: vehicle flow, where people are, the video and image data, the geographic information, because it's something not sensitive in Europe or America, but very sensitive in China. So I guess even if they have that list, one would still need to be mindful of how one deals with it, because in case of something going wrong, it could be that you are caught under the state secrets law, not the data laws, for example.
Yeah, yes, indeed, yes. So another concept provided by the new regulation, so it's now clarified in the new regulation, saying that so free trade zone. So we have quite a few like free trade zone in China. Basically, every province have the pilot zone for the international trading. So it's now clarifies that free trade zones in China can develop their own like negative list. So the concept of negative list is saying all the data listed in that list, set out in that list, will absolutely need to trigger the government procedures like SEC value security assessment. But if for any data that is not listed thereunder, so the transfer of such data can be exempted from the government procedures. So this is apparently loosen the restrictions, and the data transfer within the free trade zone will be ultimately much more straightforward if the compared to the transfer is happening to somewhere else in China. So what happened now is like some free trade zones like Lingang in Shanghai, also is the free trade zone in Tianjin. They have already making start and trying to release the negative list as soon as possible. But till now, it's still a concept. but it's also again this will
But
be
yeah. But
weird.
like free trade zones, when it comes to like stuff, so it's a bit like products. So I can use a free trade zone for some things, but let's say, for example, if I'm bringing in a product from overseas into Waigaoqiao or to Lingang or whatever, I only have to pay customs and VAT when it crosses the inner Chinese customs border. But equally, if I export via it and I do some assembly there, it's different. But is data the same? Because, like, let's say if I've got data in downtown Shanghai, I send it to Lingang, which is another part of Shanghai. Surely the rules apply when I send it to Lingang. And then maybe if Lingang does something processing with it, then maybe it falls within it. But I can't, is that right? Because I mean, it would be otherwise very strange that these free trade zones could just ignore all the other regulations.
Yeah, I think the data, as you mentioned by you, Mark, will somehow be set out in the negative list because government will also need to consider if any, like if all the Chinese companies are transferring the data to firstly to the free trade zone entities, and they will be not caught by um, uh, the general rules. But I think they must have like considered this situation. So what my guess about negative list is about like first of all important data, and also let's say some types of personal information if it's like generated together, which may like reflect some of um, the status of certain groups of people. So this might be set out in the negative list.
So it might be like I say, it might be then you would have maybe marketing or I've got market research companies or advertising companies. They
Yeah,
might have their data centers in the free trade zone, get the information, which by itself is not sensitive information, but then they would come out with the insights by generating. They process that information. That would make sense, I guess. That
yeah,
would be.
maybe. Yeah, let's see what happens in short future. I think. Okay. Um, so moving to the next slide. So it's a kind of reminder saying that apart from the government procedures, so even for companies who can successfully apply for the exemptions, but still there are some other like obligations need to be carried, taken care of. Like first of all is the notification and consent. As Mark answered, it's strongly recommended that companies still have the quite complete, clarified like notification to each individuals and have their separate consent on the cross-border transmission. So second one is the PIA, PPI report assessment. So although no government procedures is required, but according to the PIPL, so the PI assessment is still uh, required. So we guess, we not guess, is some companies are already starting to prepare some reports. So even they are not triggering the government procedures, but to ensure the 100% compliance under the PIPR, they can prepare the simplified reports to ensure that formality-wise, we have such report in place. So this is another matter. So the last matter is about data transfer agreement. So governing the data transmission from the providers to the recipients from outside China. So we highlight in practice, I think it's no need to bother, just to use the China standard contract version, especially under the situations that the transfer is between the affiliates. So it's all like with this group affiliates. So within the group, so there's no that risky to sign such like agreements because affiliates will not like chasing liabilities with each other. So let's ensure that the transfer agreement is signed with the in the version standard template version released by the government, so that to avoid any like challenges from the authorities saying that okay, this agreement is not clear or specific enough to covering the security of the transfer. So I think so. So this is the government template for the agreement is highly recommended. Yeah. So for the last page, so it's about next steps. So in short, so companies will firstly to optimize their general strategies. So especially along with the new regulations, we may take a revisit our general strategies and to maximize the possibility for the companies to seek for the exemptions. And for companies that have not do anything, so it's now the time because after years and by years discussion, uncertainty, now everything about cross-border transmission in China is now all settled. The rules are there. It's now at the time for companies to take a move, think of the a strategy play, and also to ensure and mitigate any risks of the cross-border transfer. And for companies who have already submitted or prepared their some a security assessment or SEC filing, it is possible that under the new rules, the applicable route will can be changed or simplified. So let's take another look and to switch the route to the extent as much as possible. The final note is about please do care the other compliance requirements like the consent, like the agreement, like the simplified agreement assessment report. So this is all helpful to ensure that 100% compliance under the law. So that's all the shares for today. Mark, you have any?
Okay, great, thanks. Yeah, so I guess just to summarize then, so basically these new regulations kind of settle everything except for what exactly is important data in certain sectors. But so for people that have already gone down the route, there may be optimizations to make it easier for them to comply. So they should think about it. People that have been holding off, that felt like, maybe they're not really caught by the regulations, now is the time to actually do it because it's relatively clear what your obligations are. And then I guess, the ones who at first will be the ones who will perhaps, quicker get the approvals and that. So I think, Jerry, that's a good summary. We're over time, so maybe we'll wrap it up there. And if anyone's got any questions, they can reach out. And I think you and Atticus, if Atticus can speak again, are happy to talk to people, on a friendly basis, just to see if you can help. We don't need to start charging people immediately on these things, because we do know it's a bit complicated and people probably need to think a little bit about what they want to do.
Yeah.
Okay?
Okay, yes.
Okay, well, thanks a lot. And thanks everybody for joining, and we'll be in touch soon. Thank you, Jerry.
Yeah. Bye-bye, everyone. Bye-bye.